After clause 141, amendment 101BB, Lord Dubbs.
My Lords.
We get Jeremy in,
Can I wait a minute? My Lords, I beg leave to move Amendment 101BB and also speak to other amendments that are in this group. My Lords, if I can make a slightly relevant comment, if the EU Working Time Directive were to apply to ministers in this House, I think the two ministers who are dealing with this debate might be better treated than they are now. That is a dig at the Chief Whip. But to turn to the substance, my Lords, there can't be many occasions when there is an amendment that commands the support of all parties in this House, that commands the support, I believe, of most members of Parliament in the Commons, that would command widespread support from many parts of certainly London, possibly other parts of the country where people are affected, and where the minister who would agree to the amendment or something like it would be serenaded on the headlines of the Evening Standard. That's a pretty good win-win, and there can't be many of those around. So I say to the Minister, I hope later on I'll give her a chance to say, in principle, she accepts this. If I were a Minister, frankly, I couldn't understand why the officials would advise me not to, because there's nothing wrong with this. It is absolutely right in terms of local democracy, in terms of the local people having a say, in terms of good government, in terms of the benefits to London, and I think other parts of the country as well. So it's a total win-win for the government. I should have kept my bill until there was a Labour government, and then they could have benefited from it. But I've given it with full generosity to the Minister here. My Lords, given the widespread support, I'm also delighted of outside people who've got on to me, and I'd like to pay a particular tribute to the Ladbroke Association and the Chair, Sophia Lambert, who's been extremely helpful and has given me a lot of advice and has given a lot of other people advice. And I think what I've got in these amendments is actually a complete bill. And if the Minister were to adopt it, or much of it, then I think her officials would have been saved a great deal of work in drafting something. Not only have I said there's widespread support, but there have been many previous instances in this House where members have put forward legislation and similar proposals. I think Baroness Gardner of Parks, Lord Jenkins of Rodin, Lord Selsdon, Lord Berkeley have all tabled amendments to bills. Lord Selsdon has also tabled an excellent bill himself with the help of surveyors from the Pyramus and Thisbe Club. And then in the Commons, several MPs have put this forward as well, including Karen Buck, MP for Westminster North. But essentially, this proposal goes across parties. And I would hope the government would feel able to support it. Now, the public are very much concerned, and one only has to, as it were, indicate one is interested in the bill for one to be given an avalanche of comments of experiences, certainly in many parts of London. People have told me they've suffered years of noise and distress. People working at night can't sleep in the day if a basement is being excavated. There's dust and vibration. People who work from home say they can't carry on and have to find somewhere else to work. And we're not just talking about Kensington, Chelsea and Westminster. We're talking about Wandsworth, Southwark, Camden, Richmond, and if it hasn't got to the local area where any of your lordships live, they're coming. I guarantee if we don't do something, these basements are coming. And so please don't just say, this is not for me, this is for those people in Kensington. Not at all, not at all. Now, my Lords, I've learnt a great deal about planning law in recent weeks, because I have a private member's bill on a similar topic, which is sitting somewhere waiting to be debated. But I'm conscious I have a lot to learn, and there are in this House many real experts. Can I just make some brief introductory comments? There are two sorts of developments in basements. Where they extend beyond the footprint of the house, planning permission is required. If the basement is within the footprint of the house, then it is classed as permitted development and planning permission is not necessary. And I should say, by complete coincidence, as I was coming in, I bumped into the leader of Camden Council, I asked her what they thought, and she said they would welcome a change in the law. They can't do what they want to do because they're not permitted by the present legislative framework. Now, my lords, under the Town and Country Planning Act 1990, all development needs planning permission. However, Section 59 of the Act allows the Secretary of State to make an order exempting certain categories of development from the requirement of planning permission. The Secretary of State at the time duly made an order called the General Permitted Development Order, or GPDO. One of the categories of development covered by the order at present is certain types of extensions to residential properties. Although we think it was never intended, the definition of extension in the order has been interpreted as including basement developments under the footprint of the house. Now, my lords, there are legal doubts about this interpretation, and I've talked to one resident of an in-London borough. He's a QC, so not a person to be trifled with, who is contemplating testing this point through judicial review. Something that I believe has not been done before. I think on previous occasions inspectors have been asked to comment, but he's actually said to me he's thinking of taking this to judicial review because there are serious doubts as to whether the interpretation is correct. Now, I think the right course and the easiest course would be for the Minister to amend the GPDO to exclude all basements. It could be done at the stroke of a ministerial pen. And it would save the cost of the alternative that the Minister keeps suggesting, which is to use something called the Article 4 procedure, which is cumbersome, slow and costly, and would have to be done local authority by local authority. It requires 12 months' notice, which means that people can then appeal and claim damages if they were caught with a development in train before the Article 4 procedure had its 12 months to come into effect. So amending the GPDO would be simple. It would save bureaucracy, it would save time, it would save money, and achieve the end. Achieve a part of the end. If the Minister were to take the GPDO route, however, there would still be a need for this bill. Because as things stand, local authorities are reluctant to refuse planning permission because of the cost to them of appeals. Time and time again we hear of local authorities that say, well, they're not challenging this because they can't afford the cost of the appeal. And I understand that. So this is one reason why local authorities are still granting planning permission when logic would suggest otherwise. One only has to read the Evening Standard or the Metro to see week after week the examples of horrific large developments, fine for the owner, but horrific for anybody not too far away. I believe that my set of amendments would also give local authorities the powers that they need. Now, my lords, I can go through this. If the Minister were to hint to me now that she'd be prepared to accept the principle of this, I won't bore the House and take the time of the House with going through the details of these amendments. If the Minister were to say, look, she agrees in principle and something will come back at the report stage, I shall sit down. Now, I know I've bounced her into this, but it seems to me this would be the sensible thing to do, because there's no argument on earth why the Minister shouldn't accept some change in the planning laws. There's no argument on earth. And she'd be very popular, but popularity is not the cause. Good government is the cause. Good local government is the reason. And the residents of many parts of London are entitled to peace and quiet, not to have the disturbance. Well, I'll go on. If at some point the Minister gets a note saying, accept this, then I shall of course sit down. The First Amendment sets out a code of practice for subterranean development works. It will ensure that there be some enforceable rules so that local authorities can ensure that developers digging basements do it in a way least likely to cause damage and annoyance to neighbours. And that annoyance can be pretty awful. Now, the Minister has claimed in the past that local authorities already have adequate powers. And she said it to me in the earlier debate, and she said it to me in a letter to me. She said, for instance, they could impose planning conditions to control construction noise. The advice I've had is that I need to differ from this. Planning conditions are normally used only to deal with matters that cannot be dealt with under other legislation. Noise is normally dealt with under control of pollution legislation, and many authorities fear that such a condition would be struck down. So it's not easy to enforce noise standards through existing legislation requiring local authorities to prosecute the alleged offenders. A code of practice would be much simpler. and I think what is needed is something that the developers will automatically be bound by. My next amendment is that there should be a presumption against subterranean development. Now, very few basements that are built in London bring any benefits to the local community. They may be fine for the owner to have pool rooms and swimming pools and banqueting halls and all this sort of stuff, but they don't provide any housing benefit. They're there to provide recreational facilities for the occupants. We've heard of gyms, temperature-controlled wine cellars and so on. And they bring enormous disbenefits to the local community, especially during the construction period, which can be up to 3 years, but often for much longer. So what I think we need to argue is that the disadvantages are noise, disturbance, disposing of spoil, the damage to neighbouring houses when basements are built under a terraced property, something that can take years to manifest itself, the damage, long after the Party Wall Act has ceased to provide any remedy. Sometimes there's a need for pumps in areas to pump water from basements, energy consumption in having air-conditioned basements, and the possibility that 10 or 20 years down the line, the underground structures will be degraded to such an extent that they will need rebuilding, something which I understand is extremely difficult to do. So, my lords, those are the arguments on that point. Then there's a need to give notice to adjoining owners. And although there is a Party Wall Act, it's not really designed to deal with the phenomenon, simply because it only deals with neighbouring properties that are a short distance away, whereas there can be damage to properties that are further away, and the Party Wall only deals with properties within 6 metres of the excavation. I think it should be a greater distance. I'm being very brief here because I don't want to go through all the details, otherwise the House will be fed up with me. And then there is a need to deal with expenses and losses. Developers can go bankrupt, which can leave neighbouring owners out of pocket. Developers can be difficult to pursue, sometimes through the courts, and sometimes, in the case of subterranean developments, the developer is a shadow company somewhere based in the Cayman Islands or wherever. And it is essential to ensure that funds for paying for loss of damage, which can amount in the worst case to many hundreds of thousands of pounds, are secured in advance. The Party Wall Act provides some security, but only for the expense of completing the work on the building, not for paying damage to neighbours' premises or compensating them for the loss. And then there are the problems that affect people who are living in a property that is close to where a basement is being excavated. Many people these days work from home, and I've had people write to me and say they had to leave their homes because they couldn't go on working while the work was going on. We're talking about 2 years. We've talked about people who are involved in music, and the noise affects their ability. There are people who've had to rent offices elsewhere simply because they couldn't go on working there. And I think that surveyors are at the moment unwilling to award such costs because basement developments are sometimes or frequently combined with other works on the site outside the scope of the Party Wall Act. People may be building extensions and so on, which are not the subject of my amendments. But it's very difficult then to determine how much is caused by other works and how much is caused by the basement. The result is neighbours end up with no compensation at all, although they've been deprived of a working environment. And there are medical reasons for vulnerable people and so on. Finally, I have a schedule in Amendment 101BH, which has the provisions for a local authority code of practice for subterranean development. My lords, can I repeat what I said earlier? I've left out a lot of the points I was ready to make in the interest of time. But, my lords, can I repeat? The Minister's suggestion of the Article 4 is just not good enough. It doesn't deal with the need, and I think there are other ways and better ways of doing it. If the Minister is happy to say that she accepts the principle of this, then of course I will withdraw the amendment. We've got time at report stage to do something positive. I urge the Minister to accept the principle of the amendment. I beg to move.
Amendment proposed to insert the new clause as printed on the marshal's list.
As the noble Lord Doves has mentioned, I discussed this at second reading debate, and I think the amendments he has here are greatly improved on what I've commented on before. But there are still one or two things that I think certainly need to be ironed out before report stage. In his first amendment, 101BB, there's no mention anywhere, and unless he's planning to put in a code of practice, but there should be no weekend work in these places. Because without doubt, people do require a weekend for recovery from a heavy week's work. And starting work at 7 a.m. in the morning, many areas only allow you to work 7 a.m. until 1 on a Saturday. But even that shouldn't be permitted, because that really is going to cut into your one quiet time of the week. So I think that should be a thing. And another point, very important point, which again, every detail of these words, I'm not sure whether I've missed the point, but there should be no work permitted before the granting of permission. Very often neighbours where I did live told me they woke up to find someone breaking through their wall, and that certainly is not something you'd want or expect. Now when you get to his second amendment, 101BC, that's the one real objection I have, is to that word presumption against. I don't like a presumption about anything. Earlier, Lord Doves had in his earlier comments about, you know, if a family felt that they needed something more. It was a very subjective assessment, and he fortunately has now removed the subjective assessment and made it much more objective, and I think that is good. But I don't like that word presumption, and I wouldn't want to see the word presumption. I think it's far better for things to be either in law or not in law, but just to be presuming something's there worries me. Notice to adjoining owners, I think that's very interesting, an amendment, but I move on to 101BE, and that is about the surveyors holding a sum, and I thoroughly approve of that, and when work went on behind me before I moved house, that's exactly what was done, and as it happened, there was no need whatsoever to draw on the amount because it all went quite well, but it's very important that it does go well, and the security of having a deposit held is important. And I do recall cases, one in Montpellier Square, another one in St John's Wood, where people went bankrupt, leaving a giant hole in the ground, some of which filled with water and turned into a really disastrous pool under your house, and because they'd gone bankrupt, no one ended up with any liability for them at all. So I do think that it's very important to determine a sum to be held, and I was quite surprised, even in the case which was only a single basement going in near me, I was quite surprised by the amount that was required to be held, and yet I think it was right that it was quite a large amount, because it should be related to the area and the cost of the works that would have to be done to make the place livable again. I don't know whether there's anything more can be done to deal with bankruptcy cases to help people get out of that hole. But I think that's something, again, that could be looked at.
The noble Lord Doves, is definitely onto something here, in my view. What one reads about in the Evening Standard and elsewhere as being done to basements in London is quite amazing. I don't know whether anyone ever watches that programme, Grand Designs, but being an addict of property porn, I do watch Grand Designs from time to time. And recently there was an example of a small, typical mews house in a mews area of London, where the owner decided that he wanted to have a ballroom in the basement, and underneath that it could collapse into a swimming pool. So this was constructed after immense difficulty by affecting the local inhabitants. Unfortunately, there was a subterranean stream which was discovered when they dug down into the basement, which flooded the whole area. This is the sort of thing that can happen as a result of the megalomaniac, frankly, of some of these people. Another person wanted to, one billionaire in London wanted to show all his 24 Jaguars in his basement, an exhibition place for all his 24 Jaguars. This is absurd, frankly, quite absurd, and should not be allowed. and it will have consequences. Secondly, may I make the point, he's absolutely right that the party wall agreements, as they are at the moment, do not protect people. I live in Hammersmith and Fulham, and I found a personal example of the way that the noise is horrendous. And Baroness Gard is quite right. You want some relief at weekend from the noise. A friend of mine has had to vacate her in Piccadilly, where they're constructing a huge basement and bar and God knows what in the basement, to live somewhere else at her own expense, because she cannot live any longer. She can't live at night. It's just that the noise is horrendous as a result of what goes on. That's all night work, and never mind weekends. So there is a real problem here, a real problem, which London is experiencing at the moment, not just in rich areas, by the way, in other areas as well. As a former MP for Orpington, I can tell the examples there which are happening. So I do hope that, while I understand that as usual, these amendments, as Baroness Garn said, may not be quite perfect, I do hope that the government will be sympathetic to this. It is a widely seen problem in London, and the government should look at it with great care.
My Lords, I apologise to the House, and particularly to the noble Lord Dubbs, who I have had the pleasure of discussing this issue with, for arriving slightly late and actually delayed on the district line. I hope it wasn't by some underground development in South Kensington where we were held. I was at one point quite tempted to sign Lord Dubbs's amendment because, like my noble friend, I think that he is very much on to something. Before my noble friend on the front bench was a minister, and over a number of years there have been talks between local authorities, particularly in London, and the department, and various efforts. Lord Selsdon for a time was trying to get something moving to actually propel a response from the government, and time again we're told, oh, well, Article 4 directions are the answer. We spoke a little about Article 4 directions last night. I marvel to see the noble Baroness here on the front bench after her efforts after midnight last night. Article 4 directions are not the whole answer here, and I really do think, and it is a very strong view of local authority leaders in London across party, that there does need to be some statutory response here. The fact is that in many cases one is dealing with extremely wealthy people who will stop at nothing to push through. It's nothing to them to spend thousands of hours and tens and hundreds and millions of pounds in pushing these things. And frankly, communities need defence here. And I think it does need, I think, some statutory response at the end of the day. But I look forward to hearing what my noble friend has to say on the matter. But I do congratulate Lord Dubbs and thank Lord Dubbs for bringing this issue before Parliament.
That's what the noble Lord has just said about my noble friend, who has managed to survive yesterday's long sitting. He was hoping to get on before midnight, but unfortunately that wasn't possible, or perhaps fortunately, otherwise we might have been there till 2 o'clock in the morning instead of something like 1:45. But he's devoted a lot of time and energy to what is clearly a pressing issue. An outbreak of megalomania seems to have broken out in certain circles in London in particular. And one, from a distance, of course, one isn't quite as involved with the process, but every so often, just reading the Standard, we come up with case after case of absurd would-be developments. And I know I have friends living in North London where similar idiotic adaptations are made to buildings. So we very warmly support the amendments. And I hope the government will acknowledge that there is a real problem here and will agree to deal with it. And while they're doing that, could they protect the block of flats in Balham, where I have a flat, from the underground workings for Crossrail, which is likely to cause certain problems to me and lots of other people?
Well, my lords, could I just join with the noble Lord opposite in congratulating the noble Lord Dubbs. for his tenacity last night, not leaving, I think, till gone midnight. And my heart did sink when I realised he would not get on to have his say. Noble Lord was one of the first people I met when I came into this house, and we share a common interest. I certainly have great sympathy for anyone who suffers some of the things that he talks about, and we've discussed the Death Star basement in this house, and the collapsing mansion. So I'm not in any way denying that these issues exist, and I thank him for bringing them to the house's attention. But of course, I'm going to disappoint him, because I'm going to tell him that the powers that he has described already exist, and in fact, in some cases, are being implemented. Local authorities are already able to prepare codes of practice for subterranean works in their area, and many prepare area-specific guidance to help owners to ensure that they carry out the works legally and safely with a minimum impact on neighbours. As this amendment replicates powers that already exist, it would be unnecessary to include it in the bill. Turning now to Amendment 101BC, local planning authorities are able to bring forward specific local plan policies limiting the scope of basement development if they consider that such developments are a particular issue in their area. And in such cases, any planning application should then be determined in accordance with that policy. It's not an issue in most local authorities, although I accept what the Noble Lord says, it's coming to an authority near you. But we know that local authorities in areas which are particularly affected by basement developments, such as Kensington, Chelsea and Westminster, have already or are in the process of introducing the appropriate local plan policies to mitigate the impacts of such developments. And we've looked at a graph together in terms of how the trend appears to be going. And I think what we're seeing some of now, just to put it in context, is the hangover from previous permissions that are nevertheless causing distress in the area. But I would be very interested to see how things are looking, say, 6 months to a year from now. But as I say, the amendment isn't necessary for the same reasons that I've explained in Amendment 101B. Regarding Amendment 101BD, the Party Wall Act provides legal protections to owners of adjoining properties, but it's not in place to protect owners beyond next door, as there is unlikely to be damage to properties beyond the current distances set out in the Act. Similarly, introducing a new offence as this amendment proposes would not provide any greater protection to adjoining owners. In any case, there's no evidence of significant numbers of cases where notices required under the Act are not being given in respect of subterranean developments. In addition, the amendment before us today introduces a new liability that goes beyond that currently imposed under the Limitation Act of 1980. It would be difficult to justify singling out subterranean development over other forms of development for this enhanced liability. The Party Wall Act already applies to most subterranean development work and already provides for security for expenses to be covered by the award between the parties. Therefore, Amendment 101BE is also not necessary. The Noble Lord made the point that noise is not usually dealt with in planning permission. My Lords, the local authorities can consider local impacts when granting planning permission, including noise pollution, and the MPPF deals with noise, stating that where relevant, this should be considered by the local authority in their planning decision. He also made the point that GPDO allows basement development, but, my Lords, it is for individual local planning authorities to determine if development is within the scope of national permitted development rights. He also made the point that Article 4 process is too burdensome, too bureaucratic, and too and so local authorities are unlikely to follow the approach. It can take 6 to 12 months, but it isn't particularly burdensome, and I don't think it's particularly bureaucratic in the sense, but I do accept on this point, and my noble friend behind me would probably be shaking his head if I had eyes in the back of my head, that this is a particular problem in particular parts of the country. My Lords, if I could turn now to the amendments 101BF and 101BG, 101BH, and my Lords, as I've set out already in the response, the noble Lord's previous related amendments, basement developments are not an issue in all local authority areas, as I've just said. We feel that existing powers are in place which enable local authorities to adopt an appropriate local approach to mitigate the impacts of such developments where necessary. Similarly, existing legislation protects adjoining property owners from the potential impacts of such developments. And I would therefore ask the noble Lord to withdraw the amendments.
Well, my Lords, I'm grateful to all noble Lords who took part in this debate. I know there are others who, because of the timing this morning, probably weren't aware we were doing it now and would have been here. Could I? I'm grateful to Baroness Gardner for what she said, and I very much agree with her. Although I would say that in the last amendment, 101BH, where it talks about a schedule of provisions for local authority code of practice, one of the codes, it deals with the hours of construction and excavation and the particularly noisy types of construction and excavation, which I think could deal both with the time of starting as well as with weekend working. I mean, if it needs strengthening, I agree entirely. I agree entirely with the principle that she's put forward. Both the weekend and the starting time. I think she had a third point. I'm not quite sure what the third point was. I'm sorry. The presumption, yes. Frankly, if the Minister were to accept the principle, I would be happy to drop the word presumption. I put it in out of the sheer frustration that people who approached me have felt and said, for heaven's sake, to stop all these things. And so most people would like that presumption, but if it made for better law, then the word presumption wouldn't have to come in. I think local authorities would understand what they could do. I'm grateful to the noble Lord Horham for the examples he's given me, and the noble Lord too, with whom I've had a discussion about this, and who after all speaks with the authority of being the leader of an important London borough. And if he feels his powers are not sufficient to deal with the problem, then I have to say, with due respect to what the minister has said, I think we have to listen to local authority leaders. They're the ones in the firing line. They're the ones that want to do best for the people in their community. That's what they're elected for. And I mentioned earlier that I bumped into the leader of Camden Council, who was saying the same thing, and said, despite the powers the minister says local authorities have, she said there aren't enough. We need more powers to deal with these things. And I said, may I quote her? And she said, yes. And that was a conversation that took place about 10 o'clock this morning. So it's hot off the press. Could I deal with the comments the minister has made? Clearly, her view is that powers already exist. Well, they're not. Frankly, the powers don't already exist. The minister said that local authorities could prepare codes. Yes, they could prepare codes, but they're not enforceable. The point of the codes in my amendment is that they're enforceable. Local authorities can have these codes, but they can't make them happen. I don't want to get into a long debate about the Party Wall Act. All the advice I've had is that it is not sufficient for this purpose. It does some good things, but it doesn't deal with all the problems I have described. And I just have to act on the advice I've been given from people who know more about it. The party, yes, I give way.
I'm certainly very grateful to the noble Lord. He's of course quite right on the point of the code. I mean, we do have a code, but the question is enforcing it. I should have made clear on Article 4, which he hasn't mentioned. Of course, one of the things, we have an Article 4 direction, which is chasing the game in any case in football parlance, and takes time. You then can't charge a fee. So you immediately lose even the ability to charge a fee in many cases for processing the planning application, which is then necessary under Article 4.
Well, I'm most grateful, and that deals with most of the other arguments. My lords, can I just say this? I hate to put it this way, but I think the minister has been trapped by her civil servants. You know, I've been a minister. I know what happens, and sometimes you just have to say, no, I'm not happy. You're pushing me into a position that I don't want to be in, because actually, in my heart of hearts, I said I believe in a modification of policy, and I can't help thinking that if the minister were to reflect, she would say that the weight of opinion is entirely against her. It's entirely against the advice she's been given. It's not these are not things I've invented. Local authority leaders are individuals of substance. They're elected, they represent their areas, and they want to do the best for them. This is not some political fantasy, and it goes across the party divide, not something the Labour Party has invented. In fact, they're far more conservative who've pushed me than there are Labour people. So I'm not being at all partisan on this. I would just like the minister to think again. Otherwise, we'll have to have this debate again at report stage. And I'd much rather not. I'd much rather we debated a proposal coming from the government, and I'd be happy to say, fine, that's good. Now, the minister wants to. I'm happy to give way. I'm so sorry. Well, we're all a bit tired after yesterday evening, so I misunderstood that. But my lords, I'm not happy about it. I think the weight of opinion is against the minister. I deeply regret the line that she's taking. I hope over Easter she will pause to reflect. Otherwise, I'll have to bring this back. In the meantime, I beg leave to withdraw the amendment.
Your Lordship's pleasure, the amendment be withdrawn. The amendment is finally withdrawn. The amendment 101BC is not moved. And BD 101BD is not moved. And 10BE not moved. And BF and BG not moved. And amendment 101BG has already been debated, not moved. In clause 142, amendment 101BGB. Lord Greaves.
My Lords, I rise to move amendment BGB. We are moving on to clause 142, which is about planning obligations, section 106 and so on. Amendment and what the new clause does is to set up a new procedure for resolution of disputes, and there's a new schedule in this bill which forms, I think, the new Schedule 9A in the Town and Country Planning Act 1990, and it sets up a new, quite a complicated procedure for resolving disputes on Section 106 obligations when the local planning authority and the applicants are having difficulty coming to a conclusion. And my amendment is just to apply this to Section 106 agreements in relation to housing rather than Section 106 agreements as a whole. I think it is generally true that there are really two types of Section 106 agreements. There are those relating to housing and affordable housing, which are often a matter of great controversy and difficulty in coming to conclusions, and indeed have been subject more recently to subsequent ways in which they can be lifted or the alleged burden of them reduced. But they are they're in a wholly different sort of category to normal Section 106 agreements, which are simply providing necessary local infrastructure, nowadays closely related to the actual site of the application. And this procedure seems to be long, convoluted and complex in relation to ordinary, simple Section 106 agreements, and seems to me to be a procedure which may result in applicants dragging out discussions longer than they need to, in the hope that they can get off with paying a bit less. So that is, there are other perhaps more important amendments in this group from other people, but I think this point is it's a sledgehammer, really, it seems to me, that the government is wanting to use in relation to what are quite small nuts. I move.
Member proposed clause 142, page 72, line 14. Insert the words as printed on the martial list, amendment 101 BGB.
My Lords, my name is attached to Amendments 101C and 101D, and in a sense, I can be brief about this because we discussed the issues from which these two amendments are derived during our consideration of the housing elements of the bill earlier at committee stage. The first amendment wants it to be made clear that this bill should be about all tenures of housing, not just owner occupation. And secondly, in the proposal in Amendment 101D to leave out lines 6 and 7, which gives the Secretary of State power to define affordable housing, however the Secretary of State wishes to define it, I think is a problem, and I think that these words should be removed from the bill, and I hope the Minister will in a moment concur. But also we did discuss in some detail the definitions of affordable housing and affordability, and I've had a concern that the government muddles the two terms. And now, because we have a statement right at the very beginning of the bill that starter homes are to be defined as affordable homes, when for very large numbers of people they're not affordable at all, on all of the evidence that we've been supplied by organisations such as Shelter, it seems to me to be wrong to be using terms which cannot be justified. It seems to me to be even more wrong to give the power to a Secretary of State to redefine terms which are already wrong. And affordable and affordability, you know, they have clear dictionary definitions, and whichever dictionary members would care, the Minister would care to consult in the library, the definitions are always the same. They relate to people having the resources to pay the bills. And when so many cannot pay the cost of a starter home, it is wrong to define a starter home, therefore, as affordable. So, my Lords, I hope the Minister will be able to respond. But probably these amendments will be, at report stage, brought back in a form that joins them to other definitions or concerns, other concerns about the nature of affordability.
Before the Noble Lord sits down, I take his point. And I think many of us would agree that the government's notion of affordability is far removed from that of most other people. But the thrust of the amendment is surely right. What alternative is there in the Noble Lord's mind to ensure that there is a definition which relates more to what he and I and many others would regard as being related to the circumstances and means of those who wish to occupy this property?
Well, I agree with the Noble Lord, and in fact we did discuss this at a much earlier stage of the committee's proceedings, and that related to the fact that affordability ought to be defined in relation to people's incomes and medium incomes, and that is the point that I entirely concur with.
My Lords, can I intervene briefly and raise an issue which I touched on second reading, and again in the debates which we had on the right to buy for housing associations, and the impact of Section 106 agreements on the voluntary agreement with the National Housing Federation, which says that every housing association tenant would have the right to purchase a home at right to buy level discounts, subject to the availability of funding. A large number of housing association properties have been built under Section 106 agreements.